Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA or Latin America to learn how to manage your IP assets and expand your business successfully.
Good morning, Europe, and good afternoon, Southeast Asia. Welcome to our webinar today, where we will speak about the role of IP in the digital economy. This webinar is organized in collaboration by the Southeast Asia IPSME Helpdesk and EuroCham Singapore. My name is Nora. I'm the project manager of the Southeast Asia IPSME Helpdesk, and I will be today's webinar moderator. And joining me shortly are three speakers: Nele Cornelis, Executive Director of the European Chamber of Commerce in Singapore; Claudia Chen, Senior Director and for Government Affairs Southeast Asia SAP; and Jonas, LINDSAY, External Expert of the Southeast Asia IPSME Helpdesk and Patent Attorney for Marks & Clerk. So before we dive straight into the presentation, let's go quickly through the housekeeping rules. So we look forward to an interactive webinar, so please type in any questions you have in your mind in the Q&A feature, and we will respond to your question live at the end of the webinar. We will be also launching some poll questions throughout the presentation, so please be active and participate in those polls so you can engage further with our speakers. And last but not least, our webinar is recorded today, so you will also can access the webinar recording later on. And before we go ahead with the presentations, I would like to give you a quick overview to our project. Well, you already listened to our video, so I will keep it very brief. So the Southeast Asia IPSME Helpdesk is a project of the European Commission to support small and medium-sized enterprises from the EU to protect and enforce their intellectual property rights when expanding to Southeast Asia. All services that we offer are free of charge. And the services you can see on the slide. So you can have one-to-one consultations with us through the inquiry helpline. You can find different IP materials on our website. For example, we have an IP fact sheet on Singapore. We have some industry-specific guides, for example, on IoT, fintech, artificial intelligence. So you can access to all these publications. And we organize trainings throughout the year in Europe and Southeast Asia, mainly online. So we are always happy to have you as an attendee for our trainings. And now I would like to hand over to Nelle to give a quick introduction from the EuroCham Singapore side.
Thank you, Nora. You can hear me?
Yes.
Yeah. Well then, good afternoon or good morning. On behalf of EuroCham, indeed, I would like to welcome you all for this webinar, a very important topic, the protection of our IP in the digital economy. Again, welcome today to our members, friends of EuroCham, but also in the audience we have students from NUS and NUS Business School. And I also saw some of our newest members, so a very warm welcome to these people as well. And then, of course, people to Europe, good morning. As Nora said, I'm Nele Cornelis. I'm the Executive Director of the European Chamber here in Singapore. And of course, I'm very grateful for our co-organizer, the Southeast Asia IPR Helpdesk, to do another successful event today, because we have already a good history, a good practice of similar events in the past. And of course, we are proud and happy that we can continue this fruitful collaboration. So allow me, I'll take this opportunity very short to explain you a bit what EuroCham is, what we are doing. In a nutshell, the main objective of a chamber, and we have chambers in a lot of third markets globally, and especially here in Southeast Asia. We have 9 European chambers in the region. But here in Singapore, mainly we provide European businesses that are based already in Singapore, a channel of communication, a channel of advocacy, and basically creating a platform towards Singapore authorities, but also towards European political and economic circles. So with our members, we tap into a pool of expertise, of experiences, coming from the European businesses and of even the Singapore businesses and Singapore stakeholders. So to speak, actually, you can say that the chamber acts as a bridge of knowledge exchange. And that's a good example what we see here today as well. The chamber has 13 committees, topic-driven and sectorial-driven committees. Like today's session is supported by the IPR committee. And we have a very good leader there. The committee is helmed by Sharmini Lohadasan. I'm not sure if she's attending today, but she's an employee of BP Legal. And also the Digital Economy Committee has a stake in the session today. And there, that committee is chaired by Antonio Ferraco, and he is from TÜV Süd. Now, the efforts that are done in the IP committee are in full alignment with the agenda of the IPR Helpdesk. So the steering group and the members from that committee have been working on topics like illicit trade, working on campaigns for education and awareness. We've been working on border enforcement, both for passengers and for cargo. Digital enforcement, absolutely, yes. Also, that is a topic that the committee is dealing with. We had meetings even with all the different digital platform operators like Lazada, Shopee. And then the free trade zones, monitoring and enforcement is also part of their agenda. Now, to cover all these topics, we, of course, we have our pool of members, but we also have our stakeholders besides IPR Helpdesk. We have been also engaged with IPOS, the Intellectual Property Office of Singapore, or Singapore Customs, Also the Immigration and Checkpoints Authority, or Interpol, Singapore Police Force, the International Trademark Association, just to name a few. But you can see that actually this committee is very much engaged in the topic, and the members are bringing very much value to the challenges that we face today. Also the digital economy, so we are tapping into similar important topics. Actually, 2 days ago, we had a session with that committee, and it was on blockchain. So sometimes also a solution for the intellectual property protection. But today's session on the intellectual property protection in the digital economy. Well, today we try to gain insights from direct experiences of our speakers. Those are leaders in the field. And we will look at examples of how the new technologies are creating value across the different industries, but at the same time, as I said, cause some challenges in the protection of our IP and brand protection. Now, Singapore and the EU have signed a free trade agreement. You might know that it was signed in 2018 and is in force since 2019. And there is a chapter in it, and the chapter is about IP. And that gives benefit to the users of the agreement from enhancement of the IP rights protection. The fact that this chapter is in such an important agreement, well, it only proves that the EU and Singapore share the importance of this agenda, and that they are key partners to find together solutions for the highest protection as possible. Now, Singapore often also acts as a stepping stone for the region, equally for the free trade agreements that are now following. Vietnam followed, and I think they are now in negotiations with Indonesia, Malaysia. So hopefully also in these agreements, we would see a similar chapter. And with that, I leave basically the real content of the session in hands of our distinguished experts and speakers today. So Nora, I'm going to give you back the floor. Thank you.
Yes, thank you very much, Nana, for this nice introduction. And yes, I think we should dive into the topic straight away now. So I would over it to Claudia, so she will give you more information on this exciting topic. Claudia?
Thank you, Nora, and thank you, Nelly, for the great overview and sharing on what EuroCham has done. Very honored to be here today to share with everyone just some thoughts. What I'll do is to touch on some high-level thoughts and highlights of some how the digital economy has really changed the way in which we consume, we buy and sell, we communicate, and in the way we do business. I think in one way or another, all this has some IP implications as well. I think maybe to start off first on the topic that's very dear to all our hearts, right? With all the restrictions that's brought by the COVID pandemic. I think e-commerce is one area whereby how we buy and sell and how businesses buy and sell have changed. The consumption patterns of consumers have changed greatly, and businesses have to keep up with that. So I'll say that with digitization of the economy and the way we do business, one great area is that opportunities for brands and businesses to monetize their intellectual property has greatly increased. But at the same time, it also opened the doorways to a lot of abuses or infringement of IP. For instance, when I shop on platforms, and we just had a webinar discussion by another association this week, we are talking with the e-commerce platforms and also the brands themselves on what are some of the challenges. I think the key thing that for a consumer is often wondering what I'm buying online. Is it the real thing? Is it the authenticity is often questioned in mind, and that's one area where a lot of technologies could come in to further build the protection around it, as well as to address the concerns. I think the other area that has really exploded in terms of digital content and the IP that's involved as well is the creative content. Whereas in the days of old. So you probably can guess how old I am from what I'm talking about. Like when we consume music or videos, right? You will buy CDs, VCDs, etc. It comes as a physical good. But these days, that creative content, whether it's music, movies, etc., is now, it can be a service. It can also be a digital good, depending on whether you want to own it or whether you want to watch it on Netflix or YouTube. It has become a service. But at the same time, as much as it has widened the doorways to lots of creators, so it's not just the big studios or companies that can create creative content. You have smaller or individual creators that can also come on the platform. But at the same time, the challenge these days is in terms of piracy, right? People could take your content beyond the fair use, beyond the copyrights limitations, and then duplicate it and claim it as their content. I think the challenge these days is in terms of enforcement. My wish list for the future is that there would be a platform whereby all of us, including the consumers of content or the digital goods or physical goods, could come on board, whereby the IP protection, identification, and rights could be codified on a platform. You would know who's the protector and who's the users as well. So I think blockchain, as Nelly rightly pointed out in the earlier webinar we had this week, could be one way to address that, because it's immutable to a certain extent. And I think most important, it helps in the enforcement and regulatory technology, making use of technology to really regulate and enforce. Right now, I'll see IP protection and in terms of lawsuits, etc., as a game for larger companies, mid to larger size companies. I really hope for the day whereby the pricing in terms of IP protection, especially for SMEs, as we saw in the video that's shown at the beginning of this webinar, is going to be democratized. I think it's possible based on some form of blockchain technology platforms, whereby we could make use of smart contracts, the track and trace tracing that's possible through blockchain. And that will help more SMEs and even individual creators or producers to really protect their IP. And that would help create the businesses as well. At the same time, in terms of consumer protection, it also helps as well, because they would know what they're consuming, whether it's the legitimate thing or not. And I think the interesting thing opening to the future is the large volume of digital content that will come on board, just in terms of some processes, not just the technology. For instance, art these days, instead of selling a single art piece, you could have it digitized. You could have it as a digital token, the tokenization, meaning there are more revenue channels that comes in as well. So how much you could make from your IP is really open to the disruption, or rather the new innovative type of business models. What I'll be very curious to hear from our presenters and also during the Q&A session is to hear from everyone, what would be your concerns and what would be, you think would be important as we move into the future in terms of IP protection. I think what Jonas is going to present next with some case studies would really delve deeper into those issues that we're facing, and it will help us open to have a very interesting Q&A session, I believe. Thank you.
Thank you, Claudia. Thank you for the introduction and to the opening thoughts on this topic before we go a little bit deeper in the IP protection part. So maybe I just wanted to comment on one thing before I give the floor to Jonas, that actually the Helpdesk have published a guide on how to remove counterfeit goods from e-commerce sites in Southeast Asia. And we also have an infographic on e-commerce, which is seem to be across Southeast Asia and also in Singapore, a very relevant topic. So I thought that maybe I will just copy the link also in the chat group. So if any of the attendees are interested in reading more details on this topic, feel free to access these materials. And then now, Jonas, the floor is yours, and you will be also sharing a presentation, I believe.
Hello, everyone. Yes, that's right. I'm just about to share my screen.
Yes, just put it on full screen.
Oh, sorry about that. Okay, sorry about that. You should
No,
be able
it's
to
good.
see.
It's good. I can see. Okay.
So yes, so my name is Jonas LINDSAY, and I'm a patent attorney at Marks & Clerk, Singapore. And I'll just skip through these slides, which I think sort of repeat what Nora said earlier on. And this is my agenda for the talk today. So first of all, I'll briefly introduce the various types of IP, and I'll mostly focus on ones that are more relevant to the digital economy and particularly copyright. Then I'll talk a bit about registration of IP, enforcement of IP, monitoring and protecting IP, and then briefly mention other people's IP and making sure you don't infringe upon other people's intellectual property. I'll then go through some case studies, and then finally there's some conclusions at the end. So first of all, what is IP, intellectual property? Intellectual property effectively is something that gives the owner a limited monopoly. Often that monopoly allows the owner to stop other people doing certain things in relation to that work. So for example, copyright gives the owner the right to prevent others from copying the work. Generally, copyright exists automatically once a work is recorded. So for example, if you make a video, then automatically you gain copyright in that video once it's recorded. Or if you produce a written work or a photograph, again, you have copyright in that written work, that photograph. The next type of IP is trademarks, and trademarks protect brand names or logos or slogans. Trademarks are registerable rights. That means you have to register the trademark with the Intellectual Property Office. Generally, trademarks and registerable IP rights are national rights. So you would have to register your trademark in each country that you want to protect the mark in. And trademarks are also registered for specific goods and services. So you need to choose what kind of things you will be selling under the trademark and indicate those on the trademark application. The next type of IP is patents and registered designs. And these patents protect ideas, so slightly sort of deeper and more fundamental than copyright, which more protects the expression of ideas. And again, patents and registered designs are registerable IP rights, and they're country specific. And one particular thing about patents is the process of registering and obtaining a patent is often quite involved and time consuming and costly. So of all the types of IP right here, patents are probably the most expensive to register and the most time consuming to register, but they possibly protect ideas in a sort of a broader manner, whereas things like trademarks are relatively easier to register, but only give protection to a particular trademark, or copyright protects a particular expression of an idea. The next type of IP right is domain names. And that's a very sort of specific right. That's if you register a domain name, then that gives you the right to control what people see when they access that domain. So when they type a certain web address into their web browser, you can, if you own that domain name, you can control what they see under that domain name. And then finally, these aren't quite sort of intellectual property in that you can register them, but you can protect things by either keeping them confidential or by controlling access to them. And sometimes that can be a very important way to protect your intellectual property, because if you have a business model where you can keep parts of that secret, so if you have an underlying database or an underlying server system, and you can control access to that database or access to that server system, you can use that almost physical protection to stop other people duplicating your business, and thereby protect your intellectual property. And a sort of a benefit of that is that you don't then have to have problems with enforcement, because other people can't access that data. Okay, so now I have the first poll question for our audience, and this is, have any of you registered any IP rights? And there are 4 options there. So yes, I've registered a trademark. Yes, registered a domain name. Yes, registered other IP such as a patent or design. And finally, D, no, I haven't registered any IP rights.
Okay, so we give a few seconds to participants to select an answer which is suitable for their case, and then Jonas will comment on that. This is actually it's a good information for us to know a little bit more, the audience, to take the presentation further later on. Okay, I think we can share the result. So you need to convince the participants a bit further, Jonas. I see 46% have not registered any IP rights, and actually the ones who registered, it's mainly on trademark or patent and design, and only a small percentage for domain name. So I give back to you the control, Jonas.
Okay. Thank you, Nora. That's quite interesting. I suppose it shows that many of you are probably at the beginning of your kind of IP journey, but you're still possibly wondering what the value of registering IP rights is and protecting IP rights. And yeah, hopefully from this presentation and these discussions, you'll have more understanding of the value of protecting IP rights, and then hopefully have more interest and possibly then go ahead and look into ways of registering your intellectual property. Okay, so now I will briefly talk about registering intellectual property. Many IP rights, such as trademarks, patents, registered designs, and domain names are registerable. That means they don't exist automatically. You have to go to the IP office or apply to the IP office of the country in order to register those IP rights. IP rights generally are territorial, so that means if you want patent protection in Singapore, you have to apply for a patent in Singapore. If you want to to protect your invention in other countries like China or the US, you would also have to file patent applications in China or the US. The system is similar with registered designs and trademarks. There are some systems that you can use to sort of streamline that process. If you want to apply for, say, a trademark in lots of countries, you can file an international trademark application through the Madrid system, and that can make parts of the process faster and easier, but still ultimately you have to register your trademark in each country or each territory where you want protection. Generally, registration is based on a first-to-file system. So that means the first person to file an application for, say, a trademark gets priority for that trademark. There are some exceptions. So, for example, if you have an existing trademark and someone else applies for a domain name, including that trademark, you may be able to recover that domain name. But generally, because most systems are a first-to-file system, it's important that if you have a trademark you want to protect, or an idea that you want to protect as a patent, or a domain name that you want to use, that you apply for that early on. As I mentioned, there are some systems where you can recover things, but it's generally much more complicated and much more expensive to recover something later on, or to get rights back off someone else who's kind of fraudulently applied for a trademark that you should own, than if you initially apply for it. It's sort of, as a side to that, it's also important to check that you're free to use trademark rights if you're expanding into new territories. So if you're a European company operating in Europe under a particular brand, and then you later want to expand into Southeast Asia, just because you've operated with that brand and maybe you have trademark protection for that brand in Europe, doesn't necessarily mean that you're free to use that trademark in Southeast Asia. So it's important that before you expand, you check if you're free to use those trademarks when you expand into new territories. So now I'll move on to enforcement of IP. So I've talked a little bit about registering IP, but it's important to think about, if you're going to register it and it gives you some rights, how do you enforce it, and how do you stop other people from infringing upon your rights? And the traditional and way of enforcing IP rights is to go to court and to get an injunction. So if you have a trademark, say in Singapore, and someone else is selling goods or services that match the goods or services specified under your trademark, and they're infringing your trademark, you can potentially go to court and get an injunction or claim damages from them to stop them from doing the acts that are infringing. Particularly under the digital economy, there can be problems with this. The first problem is kind of a general problem that going to court and getting an injunction is an expensive process. It's also relatively slow, and particularly in sort of fast-moving things on the internet, the sort of life cycle of a product, it can be relatively quick, and that going to court may not be the most kind of effective way to deal with it. It can be quite difficult to identify who's infringing if someone's selling something online, because they may not identify themselves very clearly. It may be difficult to identify who the end user is, the person who's actually doing the infringement. So sometimes it's more efficient to look at alternatives. And one alternative is takedown requests. So most or almost all online platforms, so e-commerce platforms or video sharing platforms, have a procedure for removing content that infringes intellectual property, and often that's relatively straightforward process, and it's generally very quick and lower in cost than full infringement proceedings. But there are some disadvantages. So the sort of advantage, if you like, is it's often a way that you can get things taken down relatively quickly, but you can't always identify the person who's actually doing the infringing. So the online platform may take whatever they're publishing. So say they're selling something online, they may take that offline, but you may not be able to identify the infringer. You may not be able to pursue them for damages, and you may not also be able to stop them from doing similar infringements on the same platform or on other platforms. For example, if they could just register with another username and then continue selling similar products, or they could switch to another online platform and continue to sell similar products. So you may still have to sort of keep monitoring and keep requesting the online platform to take down the new adverts, if you like. Another form of dispute resolution is mediation. This is often lower in cost to actually going to court and getting an injunction, for example. And another advantage is it also avoids having the decision put on public record. So if you go through mediation, you can sort of have those negotiations and have the settlement kept confidential. And finally, with domain names, there is a domain name dispute resolution policy which you can use under circumstances to take ownership of domain names. So as I mentioned earlier on, for example, if you own a trademark and someone else registers a domain name that incorporates that trademark, you may be able to take ownership of that domain name if you satisfy certain conditions. So if you can demonstrate, for example, that the other party has applied for the domain name in bad faith, or they're using that domain name to impersonate or to imply that they have some connection with the trademark owning business. So here's a bit more detail about the enforcement of domain names. So first of all, you need to show that the domain name is identical or confusingly similar to a trademark or a service mark in which you own the rights. Secondly, you need to show that the person who registered the domain name doesn't have any right or legitimate interest in the domain name. And finally, you have to show that it's being registered, that it was registered in bad faith, was being used in bad faith. And sometimes you have to go to court to take ownership of domain names. But in Singapore, for example, there's a mediation center which offers an alternative dispute resolution service. And WIPO, the World Intellectual Property Office, also has an arbitration and mediation center that covers some other Southeast Asian countries, so Laos and the Philippines. So particularly for domain name enforcement, you can go through these mediation or arbitration processes that are generally lower in cost. And as I said earlier on, they can also avoid having lots of detail about the decision put into the public domain. So we've talked about what IP rights you can register and how to enforce them ultimately. But in order to enforce your IP rights, you've got to understand who's potentially infringing those IP rights. And in order to do that, you need some kind of brand protection strategy. So a lot of the potential infringements will take place on internet platforms, the internet, social media, and so on. So you need to continuously monitor this for potential infringements, because generally with the digital economy, that things are relatively fast moving. So it's important to sort of make sure you keep on top of this and continually monitor the internet and social media platforms for people selling products that could potentially infringe your trademarks, for example. It's also possible to conduct trademark watches for potentially conflicting marks. So that would be if you own a trademark and then someone else tries to register a similar trademark, possibly in a different country, you can file an opposition against that trademark application and potentially prevent that person from registering that trademark if you have an earlier registered trademark. And finally, there are other ways to sort of manage IP and prevent people from copying. For example, by using digital rights management that may restrict people from copying. So if you are uploading content to the internet, there may be technological ways to stop people from copying it. And that can be more effective than simply relying on copyright, because if you rely on copyright, you still have to find ways of enforcing that. Whereas if you have some copy protection built into what you put out there, then that automatically prevents people from copying. And it may also, as I mentioned earlier on, be possible to restrict access to key data or processes, for example, by keeping that data and keeping the underlying processes on a server or on a set of servers that you control, and that can potentially prevent other people from using those key parts of the data or the processes. Okay, so now it's our second poll question, and possibly because of what we talked about earlier on, that I can expect that many of you may not yet have implemented IP protection strategies, but the question is, have you implemented any IP protection strategies? Yes, I'm monitoring the internet. Yes, I restrict access or include copy protection, or no, I have not yet implemented any IP protection strategies.
Okay, thank you, Jonas. So we do the same. We leave the participants to think over the question and select the suitable answer, and then we will comment on that. Yes, I think it's quite straightforward. So let's share the result and see how our participants, yeah, so not surprising, is actually in line with the previous question, correspond to what they responded. So half of our participants have not implemented any IP strategy, and then the rest of them are divided between the first two options. So yes, monitoring internet for potential infringement, 25%, and yes, restrict access or include copy protection on content. So if you want to comment, Jonas, on the response we received.
Okay. So I think in a way that's probably what I would have expected given the answers to the first question, but it's good to see that some of you are monitoring or restricting access, which probably corresponds to those of you that have some registered rights. But again, for those of you that aren't doing this yet, it's as you go through the process of kind of identifying what IP rights you have and then registering them, it's also important after that to think about how you're actually going to protect those rights and how you're going to, for example, monitor people for potential infringements, or if you're going to restrict access or similar things to that. So again, probably given the first question, the answer to the first question, that's probably what I would have expected. Okay. So now we've talked a bit about your own IP and how you can register IP rights and how you can monitor other people for potentially infringing your IP. But it's also important to think about other people's intellectual property and do your activities infringe upon other people's IP. This is particularly important when, for example, you're launching into new markets. And as I mentioned earlier on, just because you are using, say, a trademark in your home market, if you like, and then if you launch into new markets, it's important to check that no one else has already registered trademarks for the branding that you're using in those new markets, and you may have to adjust your branding to avoid people using using the same trademarks in the new market, or come to some agreement if someone already owns trademarks that overlap with what you're planning to use in your marketing in the new markets. Secondly, when you're using content, for example, if you create websites or other sort of online platforms, it's important to check that whether you're free to use that content. So, for example, if you find images or videos online, it may be those may be in the public domain and you may be free to use those, or you may be infringing someone else's IP, their copyright, if you use those things, say, on your own website. So it's important to check with all the content that you put online that you are actually free to use it. And one important thing to consider is if you're using open source software or other open source IP, what the license conditions behind that are. Because often when you download, say, open source software modules, there may be some restrictions on the use and how you can protect your own IP in those. For example, lots of open source licenses include restrictions that you have to allow other people to use a free license to use any products that you create using that open source software, for example, and that can sometimes be detrimental. For example, if you develop a new software product and you want to protect it with a patent, you need to make sure that everything or those licenses that you've signed don't impact your ability to enforce that patent. And now I'll move on to the case studies. And the first case study I wanted to talk about is actually to do with protecting IP by limiting access. And a sort of obvious example of that is patent offices, for example, IPOS in Singapore. And on patent office websites, you can access large databases of patent information. And generally, patent offices have some obligation to allow people to search for patents and to see what patents exist. But there may also be some commercial value behind that data, and they may want to separately market sophisticated access to the database and offer commercial licenses. And in order to sort of have those two levels of access with the public database and with the access that they allow for a web-based interface, they control kind of what you can actually get out. So you can type in search for details of a single patent or a single patent application. You can't necessarily download a big table of lots of patent applications and then save that data and kind of do more sophisticated searching on that data yourself. So through this sort of controlling of access, they allow people to, on one level, to access parts of the data, but they're protecting the sort of commercial value of the full database by restricting how much people can access that, and then potentially that they can sort of retain that commercial value and maybe have a fee-paying service, or maybe use that data themselves to sort of realize that full commercial value of it. So the lesson here really is that in some cases, if you have data that you want to share with customers, for example, controlling access on some levels can preserve some of the commercial value. And often it's much easier to control access to the key data than relying on, say, copyright to protect that data. And this also applies to sort of other services that may be offered over the internet. So for example, if you have a machine translation system, you may not want to allow people to actually have access to the sort of the processing that does the translation, because then they may be able to copy that and sort of replicate your service. But if you offer that as a sort of web-based service where someone uploads some text to be translated, and then you control the server on which the translation takes place, and then they receive the results of that machine translation, you can, if you like, prevent people from copying your key data, so either your training data that underlies the machine translation, or the engine that actually does the machine translation, but still offer that service over the internet. So this isn't necessarily kind of using IP, because you're not enforcing copyright in it. Instead, you're setting up your system so that it protects your copyright, if you like, in the data or in the software by restricting access to it. So now the second case study is a company which makes videos and puts them out on YouTube, and they recommend products on their videos, and on their YouTube platform they include affiliate links so that people viewing the videos can buy the recommended products, and then they receive some commission for people going through these affiliate links in order that sort of, and that's how they generate revenue. However, another company copied the videos, because on platforms like YouTube you can sort of copy the video content, and then created, if you like, their own content which incorporated large parts of these videos, but included their own links to other websites selling similar products that may have been counterfeit products. And then this impacted the original company's ability to make revenue from the commission, because lots of users were being confused or were seeing the second company's videos and buying things through those links. And the company tried to use the various takedown options that were available to try and remove the second company's videos. And some platforms, including YouTube, took down the copy videos, but it was harder for them to prove that they own copyright in the videos, particularly on platforms where they didn't initially have any, they hadn't uploaded the video themselves. They didn't have any proof, if you like, that that they were the owner of those videos, or the owner of the copyright in those videos. And this kind of leads to a very important point about online platforms and interacting with online platforms, that to use the takedown procedures, you need to have some proof that you own the IP. And for things like copyright, for things like trademark, you have proof because you can point people to the trademark register. But for non-registrable rights, like copyright, and in Singapore, it's not possible to register copyright. In some jurisdictions, you can register copyright. But where you can't register copyright, or if you haven't registered copyright in in your video, for example, it can be much harder to prove that you're the original owner. One solution is to include some kind of watermark or identifier in the content, and then that watermark would also exist in the copied content, if you like, and then you could use that to show that you are the rightful owner, and then hopefully be able to take down the infringing content. Okay, so that's the end of my presentation. I'll just go through my conclusions, which are the digital economy presents kind of lots of new challenges for IP, particularly in Southeast Asia, where there's a variety of sort of countries with different levels of development of their legal systems, and in some jurisdictions it can be quite difficult to go through the courts and enforce copyright or other types of intellectual property rights. It is very important, though, to register IP and consider how you're going to protect your branding, your content early on, because, as I said, it's much harder later on to fix problems than it would have been if you had registered IP at first. So if you register a trademark in a country, it's much easier to enforce that than to try and negotiate with someone who already has registered a similar trademark in that country, for example. It's very important as well to consider other people's IP, particularly when you're entering new markets, where there may be people who have been operating using a similar trademark, for example, for a long time, and then you may have to find ways of negotiating with them and coexisting with them in those new markets. And finally, once you have registered IP, or once you have decided how you're going to protect your IP in the digital economy, it's important to have to maintain that strategy, so to monitor for other people infringing your IP and to work out how you're going to enforce your IP.
Thank you, Jonas. Thank you for this very detailed presentation, for walking us through the different IP types and protection. And I think from one of the key message of your takeaway, which corresponds very well to the message that we try to convey to companies, is know before you go. Think about your IP before you internationalize your business to Southeast Asia. And with that, I would like to give the floor to my colleague, Benoit, who is here with us to give some final comments to this webinar and start the Q&A session with our speakers today. So Benoit, the floor is yours.
Okay, thank you, Nora. Yes, I was carefully listening to both the presentation from Claudia and then from Jonas. And so we first heard some practical information and thoughts regarding changing in consumption behaviors brought by digitization and the digital economy. We heard some highlights about regulators and regulations in terms of IP, let's say brands versus counterfeit, official or authentic brands products, and also some music and content copyright versus the piracy issues or the inappropriate use, and how we could deal with the technology, and if technologies could help or be like a tool to solve IP issues that we are now facing. Then we had, let's say, a more technical presentation about intellectual property rights, like quick overview of the different IP rights, the registration, which is very important in Southeast Asia. And thank you, Jonas, for again highlighting these points, and the enforcement part and monitoring rights of IP rights. And last but not least, all the issues that you may face someday with third parties, because third parties also have IP rights. So I see that we receive a couple of questions for both of our speakers. So it means that people are wanting to have some more information. So that is great. And maybe I will start with one question for Claudia. You were talking about incentives that could or should help SMEs protecting their intellectual property. What is your thought about this? Is this a lack of knowledge? Is it that the costs are too high for SMEs? Or, well, if you have any further comments to this question?
Sure. My own views is how the IP protection platforms and foundations are organized right now. I would say it's pretty costly. I have worked with SMEs before, so many of them do share with me that they weigh the cost, right? Because every cent counts being a small, medium enterprise. So it's a question of whether they want to file for IP protection in their key markets, or they innovate faster than the copycats. And usually they tend to take the approach of they will innovate faster than the copycats, because when it comes to IP protection, besides filing to whether it's for your IP or trademarks, etc., or your copyright, there is also the act of, after that is a cat and mouse game, right? You have to chase after those who have infringed your rights. And it takes time and money. And many SMEs that I know tend to prefer the way whereby they will use business innovation at a faster pace to overcome competitors who have infringed their rights. Or they would calculate the cost of having that product. Let's say it's a 6-month turnover time and they're going to sell as much as they can in 6 months. Then next season, they'll have a new product. Then what I foresee for the future and what I really hope to see is that if blockchain technologies or platform, what I call trusted platform ecosystems could come up, whereby our business identities, our business IPs could be codified, then it helps to really bring things to scale. And enforcement would also be helped, because before a certain product, especially digital products, could be sold, you have the smart contracts that's built in place. So the data is not dumb data. The IP protection is not dead, but it's alive and encapsulated in the system. So people who want to use it, you could quickly check whether it's legit or not. So it does take, I think, the public sector and the private sector to really come together, because those massive blockchain trusted systems are not easy. And it will, but I foresee that the cost to delivery will be lowered, because a lot of the regulatory enforcement and checks will be automated. So once things start as a service, like IP protection as a service, if those platforms could start and governments could come in to back those and work on those with the private sector, once the costs come down, my hope is that one day, why not have that, vision that IP protection can almost be automatic. Once you sign on as a member, for instance, to a certain community, anything that you buy or sell or work through those, or content that you submit, or your IP digitized right to your physical goods could be checked through that system, then that cost of protection will come down. Right now, I think it's really challenging to file in different markets. I myself, in my early days, have written music when I thought of, filing for the copyright. I looked at the cost involved, the search involved, then I'm like, okay, I give up.
Okay, thank you very much. I don't know if Jonas has some comments about what Claudia just said, or if you want to share about what kind of incentives you would like to see for SMEs in Singapore, for example.
I think yes, a lot of the reason is the cost, and in a way the uncertainty as well, that particularly with patents where I work, it can take a relatively long time for a patent to be granted from when you apply for that patent. And at that initial stage, when you have to commit some of the cost, you don't necessarily know how successful your business is going to be, or how successful your product is going to be. So you don't know how much to invest in protecting it with a patent compared to how much to invest in marketing or developing your product, because you need that investment in marketing and development for the product to be successful. So I think I kind of agree that it would be good to see more ways of enforcing, or sort of more more efficient ways of enforcing IP. But I sort of, if you like, I see both sides of the system, that particularly with patents, they are just very complicated things, and it takes a lot of time to prepare a patent application, and you need to have quite a lot of information to do that. And often it's sort of a case of choosing the right products or the right aspects of products to protect. So I think possibly also important is making sure that SMEs have clear information about what kinds of IP rights they have, and which IP is the most suitable for their business and for their products.
Yes, totally. Okay. I see that. I think it's, well, we completely answered the question of the participant, but I see that we received a very practical, and I often see people asking this question. It's a question about, the C symbol of copyright, that sometimes it appears on products or on publication, on flyers. The person is asking, if I put the symbol, does it mean that I'm completely protected against third parties, against any infringements?
I think that the short answer is probably no. It's kind of a way of notifying people of that you're asserting that you have a copyright in something. So if you produce something like a written document, I mean, like it says in the bottom corner of this slide that we can see, that the European Union's kind of asserting their copyright in this slide. So it's putting other people on notice, if you like, but it's not completely making sure you're protected, but it's a good first step, I suppose.
So it's more or less a matter of information for third parties, but it doesn't grant you any specific protection per se.
Yes, yeah. I mean, if you like, copyright exists once you record a piece of work, so it doesn't necessarily matter whether it says that or not. If it doesn't say that, it doesn't mean it's not protected, and just by putting that on doesn't mean you're completely protected, but it's indicating to other people that you're asserting that you have copyright in that.
Okay. Well, I think the question is answered. I see one question for Claudia. The question is, do you think digital economy will one day replace totally physical traditional economy? Or maybe it's the best model would be a mix, using technologies as tools to protect, like with the final aim of protecting consumers?
I think it will be a hybrid, right? We can't run away from the physical world, but I think everything that's physical ultimately will kind of have a digital twin. So we're at the, I think, interim space of moving from the Web 2.0 space to Web 3.0, where Web 3.0 means that you will have a digital twin of everything, and it's going to be highly interconnected. I think the challenge is for IP protection is also how the way we communicate and do transactions is going to be changed. Right now, many is still in the formalized type of platform, centralized type of organization, or whether you go to an e-commerce platform or you go to the bank, it's sort of centralized. But increasingly, you're seeing that content or the way you communicate is taking a more personal feel to it. It's person to person. Is what we are hearing, like social selling. We are hearing questions like people ask, how can I be protected if I buy and sell through WhatsApp or Line, through chat groups? And I think the challenge with that, it will be educating the consumers and the businesses who want to do that. I mean, in the early days when the telephone was invented, you have people really doing buying and selling through phone, right? Through phone salesmen that call you, etc. But I think now, because there's always a digital trail, regulators, governments, and businesses, I think, have to work closely together to ensure that that digital trail, transaction, whether it's blockchain, ledgers, etc., would help to serve to reduce fraud, to protect IP. I suspect to a certain extent it's about educating users to ultimately go back to what I call trusted platform. or trusted ecosystems. I and you, for instance, can buy and agree over WhatsApp on certain business deals or transactions. But to protect myself, I probably wouldn't want to leave just like, a chat group of, conversations as my legal proof. I probably would guide the seller to go to a trusted platform where I can make the payment, make sure the contractual IP protections are there, whereby my contractual rights are protected. So I foresee that's the future. So it won't be totally digitized because you still need the physical delivery of goods, etc. But I believe that the digitization will really help to first lubricate the whole process, meaning that the logistics of the buy-sell transactions, the delivery of money, of the goods itself will be much faster and more efficient. And at the same time, it should also have the protections for both the buyers and the sellers.
Okay, thank you. I don't know if on this point Nelly wants to add something, but if you want, feel free also to jump in. Okay, I'm checking also the chat box. We have one question. So it seems that it's someone knowing a bit copyright in Europe. It's for Jonas. Are there any legal exceptions for freely using works protected by copyright in Singapore? How should I know if I fit with these legal exceptions?
There are some provisions for fair use of copyright protected works in Singapore. Most of the law is kind of governed by court decisions on this, so it's difficult to give a kind of overall a sort of very clear piece of advice, but generally the court would look at whether it's commercial or non-commercial use, how much of the piece of work is being used, and kind of what the impact on the right holder is. So if you're taking a small part of a work and it's for non-commercial purposes, and there isn't a big loss in the right holder, you're likely to be able to do that. But if it has a big commercial impact on the right holder, or you're using someone else's work commercially, then it's unlikely to be considered fair use. But as I said, it's difficult to give a kind of complete overview of exactly what is and what isn't fair use, or what isn't considered fair use by the courts in Singapore.
Yes, anyway, if people have more questions or issues, they can still reach us or the DAISY IPSME Helpdesk, or even to you, and we will forward the questions. So thank you very much, Claudia and Jonas, for the answers. And I see that, one moment. We have one question from Mark Gallinghouse. Follow-up question for Jonas on copyright. How did you expect the proposed changes to the Singapore Copyright Act will impact specific segments of copyright holders, textbooks, music, etc.?
It's a good question. So yeah, there are some changes that are being discussed to the Copyright Act in Singapore, and that gives some of those are to do with kind of how what rights people have to be recognized as creating a work. Some of those give certain exceptions, so slightly possibly extend the fair use exceptions to things like so certain educational uses of work, and they maybe clarify how people can use work for example, if you're learning things online or teaching things online, exactly which parts of the copyright work you can share, and which sort of how you have to purchase, for example, copyright in that to share that work. So I think in some ways there might be an impact if you're producing textbooks. You may need to work out exactly how you define what you're selling and what the license in what you're selling is. So if someone's, say, teaching through Zoom and they have a number of students, to make sure you're clear about whether each student has to have a copy of the textbook, or whether it's somehow there's a license for the teacher to distribute some online content and only have one license. So I think in some ways it's something that once the law is finalised, people will have to sort of study exactly what it says and think about how they're going to sell their products, or how they're going to license their products for use. And obviously, the way people are teaching and using things like textbooks has probably changed over the last year or so, because there's much more online learning and people teaching online rather than through textbooks, and that may have an impact on how people sort of market educational resources and how people use educational resources. So there's always this thing that the use of IP and the use of say educational products is developing, and the IP law has to develop to sort of recognise that and to bring it into step with that.
Okay, thank you very much, Jonas. I see that there are many things to discuss about this new Copyright Act, and we'll follow up on this topic. And now I hand it back to Nora.
Yeah, thank you, Benoit, and also thank you for participants, for the speakers, and for the good answers. So I think we discussed the topic in depth, but we can always organize a second session if we feel there is a lot of interest on this subject. So before saying goodbye to the participants, I just wanted to mention that we are organizing another webinar on the 8th of July. It will be about the fundamentals of IP for the startup sector. So if any of you are interested, feel free to sign up. You can find the information on our website. And thank you very much for EuroCham Singapore for joining us for this session, and also for the speakers. And with that, I wish you all a nice afternoon or a late morning in Europe, and hope to see you at other webinars in the near future.
Thank you all.
Thank you.
Thank you.
Yeah, thank you. Goodbye.